nothing that you're in any way familiar with. Seen these guys before, right? Big news, not big news, huge news, right? Right? It's like every single day, you open the paper and what do you see? Right? This is what happens to Bill O'Reilly and Isaiah Thomas. You turn on the television, you turn on the news station, what's the headline, right? Sexual harassment. Every single day it seems like somebody else, some other celebrity being accused of sexual harassment in the workplace. You know, I and my firm, I don't advertise like Saul at Breaking Bad. You know who that is? Better Call Saul. You know, he's on the bus park bench. His picture. You know, the stereotypical ambulance chaser attorney. We don't advertise like that, right? But I get probably a call at least once a day from a disgruntled current or former employee who is looking for advice about bringing sexual harassment. Now, if I don't advertise like Saul, imagine how many calls attorneys that do advertise like Saul get. All right. So what does that tell you? And what does it tell you that every time you turn on the TV you see another picture? This morning I turned on the news. Whose picture did I see in the stories? Woody Allen. I don't know if you heard anything about that. Related to an old issue that related to one of his, I think, a daughter or something like that. But nonetheless, it was a new one that I saw today, just this morning. So with all that's going on in the news regarding sexual harassment, although there isn't anything really that big and new as far as new sexual harassment in the workplace laws, I urge you to take this opportunity to take a look at your policies, your handbooks specifically, all right? I know most of you all have handbooks, okay? I know I've done many of your handbooks, but your handbooks probably have sexual harassment or anti-sexual harassment policy in them, all right? And I know you just gloss over, yeah, I've got one in there. Somebody put it in there 15 years ago, all right? Well, take this opportunity to look at it and make sure that it is compliant with the current law. Last year, the Fair Employment Housing Act was amended and made it a requirement that basically all sexual harassment policies in your handbook need to be revised. All right? So if it hasn't been revised in the last year, go ahead and send it to me. I'll look at it for free and just let you know what needs to be updated. All right? My guess is, unless I did it for you, it probably does need to be updated. Also take this opportunity to make sure that you're giving out the Department of Fair Employment and Housing pamphlet to new employees. You all know what that is? All right? If you don't, afraid to raise your hand, come talk to me and I'll direct you to it. You can Google TFEH sexual harassment handout pamphlet, and then you just print it, right? And it talks about sexual harassment in the workplace. Training. Any of you have more than 50 employees? Okay. So you may know that if you have 50 or more employees, you're supposed to have sexual harassment prevention training for your supervisors every 2 years. And if you don't have more than 50 employees, you're not required to put on that training. But I encourage you to think about having a brief training for all of your employees about sexual harassment in the workplace. Why? Well, number one, it's all over the news. I'm getting calls every single day. Saul's getting calls, many calls every single day. Not you, it's all. And another thing is that, you have employees in the workplace, and if they're being harassed, that's not fair, right? You don't want them to feel if they have to be subjected to this treatment in order to keep their jobs, right? You want them to be able to feel like they're being listened to, right? And the other side of the coin is by putting on this training, by having a good policy in place, by handing out the pamphlet, the Department of Fair Employment Housing pamphlet, you set up what's called the avoidable consequence defense. That's a defense for an employer, which says that you as an employer have these policies in place. You put on the training, you have a good handbook, you hand out the pamphlet, you got the poster that talks about sexual harassment in the workplace and what employees are supposed to do. You encourage reporting, right? If you have that in your workplace, whether you have 1 employee or 1,000 employees, and the person who's harassed does not report it, which often is the case, most people don't report, right? They don't want to rock the boat. If you have those policies in place, the employee doesn't report it, all of their damages will cut off from the point in which they could have reported it, right? So I'll talk to you about that after if you have any questions. Oh, one of the other things here I wanted to talk about. Anybody in the insurance industry? Okay. This last one where I talked about what I have on the screen here says consider employment practice and liability insurance. That's the type of insurance that will cover employment-related claims, sexual harassment, discrimination, sometimes wage and hour issues. Think about getting that. Your regular general liability insurance is not going to cover employment claims. It's going to be an exclusion like every other thing that insurance policies exclude. All right, new stuff with regard to sexual harassment in the workplace. AB 396 talks about sexual harassment training. We all know that if you have 50 or more employees, you have to have harassment training for your supervisors, right? Nothing new. Every 2 years. This law makes it actually increases what you need the training needs to include. It needs to include a discussion and examples about gender identity, gender expression discrimination, and sexual orientation discrimination. And the trainer needs to know about these things. The trainer needs to give examples of what's allowed, what's not allowed in the workplace, and discuss about transgender issues. I already do that in my training, so nothing really new for my clients. Okay, anybody in the hotel, motel, bed and breakfast industry? If not, I see some people shaking that maybe you might know people in it. This is a law that talks about human trafficking. Might not be applicable to every single one of you, but you may know somebody in those industries. Real briefly, what it does is it requires a notice to be posted starting January 2019, which basically allows employees, gives them the information about what do they do if they're a victim of human trafficking. It provides them the telephone numbers, the ability to text if they're in a troublesome situation with human trafficking. So veterans, military people. So we all know that in California, California has the most protected categories out of any state in the United States. And we're talking about race, religion. I'm not going to list all of them, I can't remember all of them, but race, religion, sex, pregnancy, military status, marital status, medical status, disability status, age, if you're over 40, you're protected older working American, right? This AB 1710 basically just brings California up to the standards of something in existence with federal law, USERRA. Okay? And what this does, it makes it a misdemeanor to discriminate against anybody currently or formerly in the military with regard to their job. Any questions? No? Right, anybody in the healthcare industry? See scrubs over there, is that? Okay. Animal or humans?
Humans.
Okay. I see some animal people over here. But this has to do with healthcare facilities, and it's basically a whistleblowing law. So you have people who are working in the healthcare industry, and they notice something wrong, all right? And they're afraid to blow the whistle, say, hey, wait a minute, what about this? I don't like what's going on here. And this law makes it illegal to discriminate against any employee who does that. Right? It seems like it would be common sense, but we're California, and I guess the legislators feel like they have to put it all in writing, right? But it just makes it, look at the fine, it's pretty hefty fine, up to $70,000 for punishing someone who's blowing the whistle in a healthcare facility. All right, let's talk about the first case that I found kind of interesting here. I call this the being allergic to perfume got me $3 million. All right. I also call this, or refer to, or think of this as take the interactive process of reasonable accommodation seriously. Right. Someone would perform the seminar actually caught me and asked me about someone being out of work, all right, having a medical doctor's note and not being able to come back to work. And what happens? You get a note, then you get another note, then you get another note, then you get another note, all saying you're going to be out in 30 days, right? And so it's like, when does it ever stop? All right? And that there's no clear-cut answer to that. It's going to depend on the specific facts of every situation. So in this one, Barrie, or Barrie, which is Caltrans, involved a Caltrans employee who had an allergy. And the allergy was in particular with regard to perfume and some cleaning agents such as Windex. So that employee was hired in 2005 and told his supervisor, hey, I've got this situation where people wear perfume around me, or if I walk into my workplace and it's been cleaned with Windex or whatever, Clorox, I'm going to have an allergic reaction. And the supervisor at the time provided the accommodation. You don't know what that means, accommodation. Working with the person to provide them with something to be able to help them perform the essential functions of their job. Well, what happens now? This is usually what happens when things go bad. A new supervisor comes in. New supervisor thinks, really? Windex? Come on, right? And the accommodation, in other words, the request to not have perfume around in the office and not have Windex on the glass and et cetera, was ignored. And then this particular employee started to become harassed. 2011, actually steps it up, goes to HR and says, hey, look, I told you back in 2005 I'm allergic. I can't work here if I continue to be exposed to this. All right? And then retaliation starts. The employee, at the direction of the supervisor, is then retaliated against. All right? The employee is demoted, told to do reception type work. All right? Demoted, doing other things that he's not really hired to do or overqualified for. It got to the point where the supervisor actually called the employee an idiot and a jerk and shut up. The supervisor then, get this, you see, intentionally sprayed the workplace with perfume. All right, so the employee sues, and what happens? $3 million. Okay, so what's the takeaway from this? You may think of your employee or employees who come to you with a complaint. You may poo-poo it, think the person is the boy or girl who cried wolf, constant complainer. I can call my kids a constant wanking. Complaining about everything. And every time you see the employee come walk into your office, what do? You roll your eyes and you go, now, someone's looking at me, someone's across the demarcation line on the chair, they're too close to me, and that kind of thing. Even if you're in a situation like that, you have employees like that, this is an example of why you need to take every single one of their complaints seriously. If you don't take it seriously, at least fake it. Get through it, okay? But understand that their complaints may be legitimate, they may be very legitimate. You may not agree with it may not bother you, but it may be significantly impacting their workplace, and that's not fair, right? Not fair to them. All right? You may have something that you are unable to do and everybody else is able to do physically or mentally. And if your boss poo-pooed what you were telling him or her, you wouldn't feel right about it. So engage in the interactive process of reasonable accommodation. If you don't know what that is, come talk to me after basically sitting down and talking with the employee and finding out what they need. And then you decide whether you can accommodate.